Good afternoon, and welcome to today's Professional Series webcast brought to you by the MSU Alumni Association. Our Professional Series webcasts take place the second and fourth Thursday of each month. These are free webcasts that we make available to Spartan Nation in the hopes that our content helps you in a meaningful way. So, for today's webcast, our topic is Introduction to Estate Planning by Spartan alumnus Ted Hughes. We brought him to you digitally. He has been a popular presenter for us in our evening college program, which has now evolved into the Alumni Lens. If you are in the Mid-Michigan area, Ted will be conducting an estate planning wills and trust session on Saturday, February 22nd from 9 a.m. to 1 p.m. You will hear more about that at the end of this cast. Ted has authored two sets of law books for the legal profession and is the senior author of 7 nationally published books on estate planning and settlement. His latest books include The Handbook to Wills, Funerals, and Probate and The Executor's Handbook. So, Ted, we thank you for committing this time today to Spartan Nation. We will be recording this cast, and you will see information in the chat area shortly on how you can receive a copy of the cast. We'll actually make sure you do. And if you have questions for Ted through the course of this webcast, you are welcome to place them in the chat area and he will address them at convenient times. And to avoid confusion, I am actually Lisa Parker, the Director of Alumni Career and Business Services for the Alumni Association. We had some sound challenges, so I'm logged into Brenda Haynes' system. So you will see me typing in the chat area as Brenda, and you will see Brenda typing in the chat area as Lisa. So if you can all just there, we'd appreciate it. Ted, you are welcome to come off of mute, and I will turn the floor over to you.
Thank you, Lisa. I hope I have turned off the mute button. I think I have.
I hear you. Yep, I hear you.
Very good. And greetings, all. I will be spending some time with you discussing the process that we call estate planning. And a couple preliminary comments. I'll be assuming Michigan law in my comments, although all states' laws are pretty similar when it comes to estate planning and wills and trusts. In addition, to organize our material, we have created 8 slides summarizing each of the 8 topics, and I'll be moving from 1 to 2 and 3 and so on as we talk about the material. And again, as Lisa mentioned, you're welcome to post your questions. If you raise a question that I know I'm going to be addressing in the next couple minutes, I'll probably just hold that for the moment. And lastly, it's my understanding that the webcast is those who subscribe will also be receiving or have access to a document that I prepared titled Sources of Online Information, basically a collection of websites dealing with the topics that we'll be talking about today. With that, let's move to our first topic, estate planning defined. And what is estate planning? Well, it's a process that addresses two topics. Number one, preparing for disability. Most of us will hopefully not have to deal with disability during our lives, but some of us may. And if we become disabled to the point where we're unable to handle our own affairs and make healthcare decisions, then we need to have somebody authorized to speak for us. And if we don't do that, if we don't incorporate that in our plan, then the probate court is going to have to get involved, and friends or family may need to seek the appointment of a guardian to take care of our person and a conservator to handle the protection of our estate. This can be costly, typically requires employing an attorney, and it's a level of bureaucracy that the family is going to have to go through, but it can be avoided with planning, namely by use of a couple of documents. One of them is called the financial power of attorney. The other is called a medical power of attorney. I'll be addressing in more detail in a moment. The second aspect of estate planning is preparing for death. And traditionally, that's what we always viewed estate planning as addressing. And we continue to do so. And as we think about preparing for death, we need to think about designating a manager, somebody that's going to collect our assets, pay our bills, distribute the balance. In addition, we need to think about identifying our chosen beneficiaries. Who do we want to inherit our worldly goods upon our death? And in that context, we think of identifying both primary and contingent beneficiaries. So when you think about estate planning, think about your chosen beneficiaries, but also think about backup beneficiaries in the event that your primary choice dies before you. We call those contingent beneficiaries. If you don't do something by way of an estate plan to identify beneficiaries, then state law has a plan for you. You probably will not like the way the state distributes your estate, and certainly you can avoid that by having a basic plan, either a will or a trust or some other technique that you've used to assure that upon your death, your assets, your real estate, your personal property pass to your chosen beneficiaries. What else do we do in preparing for death? Well, we protect minors. Those of us who have minor children, we need to address that. Even though our worldly assets may be modest, if we have minor children, then estate planning, a good estate plan would address a couple of things. Number one, designating a parent substitute. In the event your child is orphaned by the death of both persons before the child reaches age 18, then you have the right to designate a substitute parent, we call a guardian. If you don't exercise that right by a proper estate plan, then the probate court will decide who is to be the substitute parent, who's to be the guardian of your child until the child reaches age 18. Most parents, when they learn that, want to exercise their right to designate whether it's Uncle Jim or Aunt Mary who will have control over the children, take custody of them, make decisions regarding their education, their medical care, and other important decisions that need to be made for our children. The other aspect of protecting minors has to do with their inheritance. If you do nothing and leave assets to minor children, then they're not going to have access to them until they reach 18, adulthood, at which point they'll have full access to them, even though they may not be financially mature. Many parents, when they think about it, don't want their child to receive or have access to a $100,000 inheritance or a $50,000 inheritance or a like amount when that child simply reaches age 18. They would prefer to delay the inheritance, postpone it to an age where the child is likely to be more mature, perhaps age 23. A popular age is age 25. Sometimes when the child finishes undergrad education, maybe at that point. But in the meantime, those assets are there and they're protected and they're used to care for the child, to help with the child's education, maintenance costs, medical bills, and the like. So we try to protect minors as a part of the estate planning process. Also minimizing taxes, particularly if you have a substantial estate approaching $5 million where you may be exposed to our federal estate tax. then particular planning is warranted to minimize and, in fact, avoid exposure to some of those taxes. And lastly, another important aspect of estate planning is to inform survivors. Many times people die and they leave an estate, and their survivors, circle of family or friends, have to spend a lot of time figuring out what he left. What did he own? Did he have assets? Did he have real estate in another state? Did he have a cottage up north? Did he have 40 acres in the woods? What bank accounts did he have? And where were the banks? And what stock did he own? And who were his advisors? Who was his attorney? Who was his accountant? Was there a bank safety deposit box? Was there a mailbox at a postal service? All of those things sometimes really require a lot of searching to put the case together, put the estate together. But if a person has left information, typically in the form of what we call a letter of instruction, that certainly makes life a lot easier for the survivors, and we've informed the survivors. Now we really should move on to our next slide. Let me do this on our screen. Here we are. We're talking here about using a will. That's a primary document of estate planning. We all know about wills. Many of us think that, well, if we're going to do an estate plan, that means we've got to have a basic will. Well, you're pretty close to the mark on that. For years, the will has been, for hundreds of years, the will has been the primary document of estate planning. So let's talk about what a will is. It's a writing. We don't recognize oral wills in Michigan. We don't recognize video wills. It's a writing signed by an adult who is competent and free of duress and in the presence of two witnesses. We have three types of wills in Michigan. We have the formal will that's typically prepared by an attorney. We have what's called a statutory will, and we have what's called a holographic will. The second one, the statutory will, is basically a fill-in-the-blanks will that's been approved by our state legislature. You can get them free. California adopted this concept years ago. Michigan copied it. I don't think there are any other states, there could be, I don't think there's any other states that use a statutory will approved by our legislature. But the statutory fill-in-the-blanks will is a do-it-yourself will. If you can get a copy free by calling your legislator and asking them to mail one to you. You can get one online going to the Michigan government website, which is simply www.michigan.gov.org, I believe. And when you go to the Michigan government website, up in the search box, simply type in the name of the pamphlet that includes this free statutory will. And the name of that pamphlet is called Peace of Mind. So if you want to take a look and see what a statutory will looks like, that's very easy to do. Follow that instruction. There are some shortcomings with the statutory will. Sometimes people find them hard to understand and hard to fill in. And they're also very basic. They don't permit you to create a trust for minor children, for example, and they don't offer you the opportunity to do any tax planning. But at least a basic statutory will is better than no will. The third kind of will that we recognize in Michigan, it's called a holographic will. And that's a will that does not have to be witnessed. I call it a homemade will. And there's three requirements for a holographic will to be valid and to not need witnesses. Number one, it's got to all be in your handwriting. Number two, it's got to be signed by you. And number three, it's got to be dated. So if you take out a piece of paper and write on it, I leave the works to Mabel, and then you sign it, Ted Hughes, and date it, you have really created a will. Not a very good will. Courts and lawyers are not going to like that will because you haven't been very specific as to what the works are, and you haven't been very specific as to who Mabel is, but at least theoretically, there's that opportunity, that type of will. So what can a will do? Well, several things. They can, with a will, you can designate your beneficiaries. That's a primary purpose of a will. You can designate or even disinherit some survivors. Typically, you can disinherit most survivors except a spouse. You cannot use a basic will to disinherit a spouse. So if you are inclined to attempt or want to disinherit a spouse, then you need to use other devices if that's your wish. You can use a will to postpone an inheritance. In other words, in your will, you can say something like, I leave everything to my children, provided, however, if they're under the age of 25 when I die, then their inheritance shall be held in trust and shall be used only for the support and maintenance of that child. And then upon the child reaching age 23 or 25 or 30, then the balance of the trust assets are to be delivered over to the now adult child. So it's a very, very effective tool for protecting minor children. You can use your will to forgive debts. If your brother-in-law owes you $10,000, you can specify in the will that you forgive that debt. And also, equally important, you can use your will to designate who's going to be the manager of your estate. We call that the personal representative. We used to use the term executor, but now we use the term personal representative to describe the person who's going to manage your assets, collect your assets, pay your bills, report to the court an inventory of what you left, and determine whether there's a valid will. The court will determine that. If you die without a will, then the court will distribute your assets according to state law. But the designation of a manager, a personal representative, is an important part of a will. Similarly, if you create a trust in your will, as I hypothesized a moment ago for minor children, then you can identify someone to be the trustee of that trust, perhaps Uncle Jim. If there's nobody in the family that you have confidence in, that will be a person of integrity and will protect those assets for the minor children, you can use what we call a corporate trustee, typically a bank that has trust powers. So those are the things that you can do with a will. There are certain things you should not do with a will. For example, in your will, you should not simply express mere hopes or wishes. If you want to leave something to Uncle Jim, for example, and you say in your will, I hope and wish Uncle Jim gets my 20-foot sailboat. Well, that's not going to work. That's not going to be valid. It's not going to hold up. That language is not strong enough to carry that gift through. We call that so-called precatory language. We need to use stronger language in the will. So if you want Uncle Jim to get your sailboat, you say, I hereby give to Uncle Jim my 20-foot sailboat, so that you are speaking in strong, directive, mandatory language. Other things that your will should not do is impose conditions that are viewed as being against public policy. For example, if you have an adult son who's been married 20 years and you want to leave an inheritance to him, but you've never liked his wife, if you say in your will, I leave 50% of my estate to my son Joey, if he divorces that woman that he's been with for 20 years, that's not going to work. That would be viewed as a gift, an attempted gift in derogation of the institution of marriage. And what would happen in that scenario is the condition would fail. Johnny would get 50% of your estate, and he'd get to keep his wife. So we can't do those kinds of things with a will. Other things that you should not do with the will is to include libelous language or defamatory language. If there's somebody that's hurt you in life, or if you've had a business partner and you think he has been stealing from the business, you should not, for example, with your business partner, you should not say something like, I leave nothing to my business partner, Ralph, because he's had his hand in the till for 20 years. You have basically libeled him, and at the very least, you will be putting your estate to the expense of defending a lawsuit if Ralph finds out what you've said about him. Worse yet, he may recover a substantial amount of damages in a lawsuit against your estate, again, based on libel. So we don't want to use our will as a letter to the world to list all of our grievances. If we do, we're opening up the potential that our survivors will have to defend a lawsuit. And other things we shouldn't do with a will is to specify anatomical gifts and funeral or burial arrangements. If you want to make an anatomical gift of your body or body parts to an organization, for perhaps the Lions Club, you want to donate your eye corneas for use in their eye bank, a will is not the appropriate tool for that, because many times a will isn't found until days or weeks or months after death. And with an anatomical gift, that has to be harvested within minutes or sometimes hours following death. Again, similarly, funeral and burial arrangements, those should not be put in a will, because let's say you specify in your will you want earth burial, you do not want to be cremated, but you die and your will isn't found for a month, and your survivors may cause your cremation, not knowing what your wishes were as stated in a will. So both of those things, a discussion of your wishes about anatomical gifts and then funeral and burial arrangements, are best left to another document, sometimes called a letter of instruction, which we'll try to talk about a little bit later. So lastly, what happens if you die without a will? Well, I did touch on that. Each state has what we call intestacy laws. Michigan has an intestacy law. And if you die leaving assets in your name, but you have not left a valid will, then Michigan law specifies who is to take your estate, your probate estate. For example, if you die leaving a spouse and children, does everything go to your spouse and nothing to your children? No. Under Michigan's intestacy law, your spouse would take the first $240,000 plus half the balance. The rest it would go to the kids. And if that's something you're surprised about or object to, then you are a candidate for a will. Similarly, if you die without leaving any next of kin, but you do leave assets in your name alone, you're not survived by brothers, sisters, spouse, children, grandchildren, nieces, nephews, then you are said to have died without any next of kin surviving, in which case, under Michigan law, your entire probate estate would escheat, would be forfeited to the Michigan State Treasury. If you don't like that, then sign a basic will and specify whom you want to be your beneficiary. So let's move on to another topic, which is an important tool used in estate planning, and that's what we call a revocable living trust. And the concept of a trust is simply this. It's where you entrust someone with assets to protect them and to distribute them to a beneficiary at some point in time. So, for example, if I wanted to leave $100,000 with Lisa, and I would give $100,000 today to Lisa, and I would direct her to protect this $100,000, and then next month, whoever tunes into the webinar or the webcast next month, she is required to distribute that equally among the 40 or 50 or 100 attendees who show up and sign into the next webinar. Well, we've really created a trust. And yeah, you could even do that orally. Not a good idea. But in this context, Lisa would be the trustee. I'm the person who's setting up the trust. We call that person the grantor. And you folks are the potential beneficiaries of the trust. And the $100,000 is what we call the trust estate. Now, under that circumstance, Lisa, as the trustee, has what we call a fiduciary responsibility, which is the highest duty known to the law. She's really got to protect those assets, that $100,000, and preserve it until next month's seminar to find out who signed up so she can write a check and distribute it equally among all of you. Well, if in the meantime she thinks, well, gee, she should try to make that money grow, and she goes to the Jackson horse track and bets on the horses and loses $50,000 of that, and then shows up and reports back to you next month that she's lost half of the trust estate, then she is liable to all of you for not protecting the trust assets. Well, that's a very simplified version of a trust. What's a living trust? Well, it's a estate planning tool that in the last 30 or 40 years has become more popular as the public has learned more about it. It's similar to a will, and we call it a living trust because it takes effect during life. A couple times earlier today I've mentioned creating a trust in a will. Well, a will doesn't take effect until one dies, and those kinds of trusts created in a will are what we call a testamentary trust, meaning it's testamentary in character, doesn't take effect until one dies. As opposed to a living trust, if we set up a living trust and sign it, it takes effect during our lives. It takes effect immediately. And that's what's now become more popular and has been used as a substitute for a will, because it does a couple of things. Number one, it helps you avoid probate if you become disabled. And secondly, it helps you avoid probate upon death. One of the concepts of the trust is you've got to designate a trustee. Who are you going to designate as a trustee? Can you be your own trustee? Yes, you can. With a revocable living trust, you can be your own trustee, or you and a spouse can be co-trustees, and then further specify that upon the death or disability of either of you, the successor trustee shall be John Doe, perhaps an adult child, perhaps a bank that has trust powers. Can you change and revoke the trust? That's the big advantage. That is a big advantage of the revocable living trust. If the trust contains a clause giving you the right to change, amend, or revoke or terminate it, then yes, you can revoke your trust or change it in the future. That's why it's a very flexible tool. Now, if you want to take advantage of a trust for estate planning purposes, it's really a two-step process. Number one, signing a trust agreement, and secondly, funding the trust. In other words, rearranging ownership of your assets so they now become subject to the trust. So if you set up the Ted Hughes Trust, and I have done that for myself, my wife and I have set one up a long time ago, then the next step for us to do, and we did, we transferred our home from our individual names over into the names of Ted and Elizabeth Hughes, trustees of the Hughes Family Trust. That makes our house now subject to the trust, so that upon our disability, the successor trustee can deal with our house, can sell it if need be, can make changes to it, and then upon our death, the successor trustee is duty bound to dispose of the house according to the terms of the trust. Big advantages of the living trust, as I touched upon, is number one, it avoids probate if you become disabled. If you become disabled, then the successor trustee of the trust can manage the assets in the trust, use all of the assets to protect and support you until your death, and then upon your death, there's another opportunity to avoid probate by using the living trust. The successor trustee doesn't have to take your estate into probate court. instead can make distribution of all of your assets immediately after death or according to the terms of the trust. Now, having set up a revocable living trust, the question pops up, do you still need a will? Yes, you do. The advantage of still having a will is sort of a backup tool, so that if for some reason you have failed to rearrange and retitle your assets so they become subject to your trust, or upon your death you come into assets that were never in your trust, then the will can serve as a pour-over tool to transfer any overlooked assets or any newly acquired assets over to the successor trustee of your trust, and then those assets become subject to the trust. So that's the advantages of the revocable living trust. Let's move on to a topic that I've touched upon, and let me see if I can move. Here we are. Probate court. You've heard me mention probate court several times. What is probate? What does probate court do? Well, probate is the name of a court in Michigan. Michigan has 83 counties. In each county, there's a probate court. In Michigan, one of the responsibilities of the probate court is to supervise the administration of decedents' estates, meaning the administration of estates of people who die and leave assets in their own name. Other states may have different, or many states call this court a probate court. Some states, however, call it a surrogate's court. Maybe they use other names, but basically the probate court in Michigan and in other states has several responsibilities. Number one, the probate court is duty bound to designate a manager of your estate. If you've not left a will, then the probate court will decide who's going to be the personal representative of your estate. The probate court, through the designated personal representative, will inventory your assets, find out what you own, what it's worth, where it's at, and then make sure it's distributed either according to the terms of your will. If you left no will, then according to state law. Now, what are the problems of probate court? Why do people sometimes talk about avoiding probate? Why are there so many books out there on how to avoid probate? Well, the main problem of probate court administration and why people think about or oftentimes try to avoid it is the expense. It can be expensive for survivors. Fees in Michigan range from 2 to 4% of the value of the estate. So if the value of the probate estate is $100,000, then the legal fees are going to be roughly 2 to 4% of that $100,000 to finish the probate administration process, to settle the estate and get the assets distributed to the entitled beneficiaries, who would be those named in the will, and if no will, then those persons designated by state law. So the primary concern, objection to probate is the expense incurred by the survivors. There's also the delay of several months, typically, to finish the probate court process and to get all assets transferred over to survivors. Another objection held by some people to the probate process, it's fully public in nature. Everything that happens in probate court, your will and all of the documents and all of the results, are all a matter of public record. So if privacy is of concern to you, then that's an argument to support avoiding probate. Now, do all estates go through probate? How do we avoid probate? Well, one of the techniques, the primary technique on avoiding probate, is to avoid dying, leaving any assets in your name. Because probate court administration, and I know this is a little difficult to follow if people are not used to the terminology, But probate court administration of your estate is only required if you leave probate assets. What's a probate asset? A probate asset is an asset that's in your individual name at the moment of death. So, how do you avoid probate? Well, one of the ways of avoiding probate is to die or arrange your affairs so that when you die, there are no probate assets in your name alone. Basically, let's say you've put assets into joint ownership or one of the other techniques, and we'll be talking about the various techniques on the next slide on how to avoid probate. But if you die without leaving any assets in your name, then there's no need to probate your estate. So what's another way of avoiding probate? Well, giving all of your assets away before you die. Is that a wise technique? No, that's not. Once you start giving assets away, a gift is irrevocable. You can't get those assets back if you need them. So theoretically, if you gave everything away to friends, family, charities before you died, then yes, you would avoid probate because at the moment of death you wouldn't have any assets in your name. However, making gifts of assets in order to avoid probate is a practical matter an unwise technique. There's a couple, let me diverge or just go back to a couple of points, a couple of rules of probate, or I should say a couple of rules of estate planning. These are rules that I think are important. And number one is to keep your plan simple. Don't try to engage and sign documents that create a complicated plan that you don't understand what you've done. So rule number one, keep it simple. And rule number two, keep it revocable. In other words, don't use any estate planning technique that's irrevocable, that you cannot unwind next year or change your mind about next year. Keep your options open. So keep it simple and keep it revocable. So let's go on to the next slide, and we'll talk specifically about the various techniques that are used to avoid probate, to arrange your affairs so that upon the moment of death there are no probate assets in your individual name. Therefore, your survivors don't have to go to the expense and delay of probate court administration. A very common, and there's the list right there on that screen number 5, a very common technique used to avoid probate is to title your assets or arrange your assets so they are in joint ownership, namely owned by you and somebody else jointly. Because the basic feature of joint ownership is upon the death of one owner, the assets automatically pass by survivorship to the surviving joint owner. For example, if you own a $100,000 home, it's in your name alone, and you decide to make it joint between you and, let's say, an adult child, and you sign a deed transferring the asset from the name of Ted Hughes over into the name of Ted Hughes and Mary Hughes, let's say that's my adult daughter. I have created joint ownership of my home. I would then record the deed in the County Register of Deeds office and would have effectively created joint ownership of my home. Is that a good idea? Probably not. There are several problems with joint ownership. Once you title real estate or even personal property in your name and in the name of another person, that's an irrevocable step. In other words, I can't get my daughter's name off that deed unless she consents to deeding back her half interest to me. So number one, that's a major problem with joint ownership. And by the way, many of these same comments of joint ownership will relate to joint ownership of personal property as well. For example, bank accounts, stocks and bonds, valuable collectibles, and then of course joint ownership or even motor vehicles. But so let's stick with the house for a moment. Let's say a couple of other very major concerns, problems, negative features of joint ownership is I've made my house joint with my daughter Jenny or Mary, and then I decide I want Jenny, excuse me, using my real daughter's name here, Mary. I want my daughter Mary to release her interest in the house because let's say I get married, or remarry, or simply decide I don't want my daughter to have the house when I'm gone. I want it to go to a charity, or I want it to go to a friend. And I asked Mary to give me a deed, and she declined. So I've locked myself into that irrevocable situation of now having to co-own my home with my joint owner. Another problem, if my joint owner, my daughter Mary, goes into bankruptcy, well, then half of the property is subject to the claims of her creditors in bankruptcy. Or let's say she is in a major automobile accident and doesn't have enough liability insurance. My home is now exposed to the claims of her creditors resulting from that major automobile accident for which she did not have adequate insurance. So these are problems with joint ownership. Typically, joint ownership is okay between husband and wife if the marriage is sound. If the marriage is not sound, then a person ought to think very carefully about in the future putting assets into joint ownership with his or her spouse. There's another, and by the way, let me just add, yes, the advantage of joint ownership that it has the potential for avoiding probate. So let's say I make the house joint with my daughter Mary, and then I die tomorrow, then the house automatically passes free of probate court administration to my daughter Mary. No delay, no need for lawyers, no 2 to 4% legal expense for going through probate court administration. So that's the real advantage, but the downside, the negatives, sometimes outweigh the advantages. There are other things that one can do with that home to avoid probate without the disadvantages. But again, a couple more techniques for avoiding probate. Let's say life insurance. Be sure you have on your life insurance policies a designated primary and alternate beneficiary. Because if you die and your primary beneficiary has died before you and you haven't designated an alternate, then the life insurance becomes a probate asset, has to go through probate court to be distributed according to your will if you left one, otherwise according to state law. Similarly, on retirement accounts, be sure to designate a primary and alternate beneficiary so that upon your death, the money passes according to the beneficiary designation, doesn't have to go through probate court. Bank accounts, credit union accounts. In the old days, 20 years ago, basically the only technique of avoiding probate was with joint ownership. Well, we have another technique now. We can use a pay-on-death beneficiary on bank accounts. We call it a POD beneficiary. So you can own all of your bank accounts in your name alone, have full control. Those accounts are not accessible to anybody else, but on that ownership on the account record, you can designate a POD, a pay-on-death beneficiary. Upon your death, whatever's left in that account goes to the beneficiary. However, during your lifetime, that beneficiary has no access to, in your account, has no exposure to the claims of that person or her creditors. Similarly, on brokerage accounts, you can use a similar concept called a transfer on death, a TOD beneficiary, to avoid probate of those accounts, but again, not expose those accounts to the control of your POD or TOD beneficiary. And again, the nice thing about POD and TOD beneficiary designations, they are revocable. You can change your mind tomorrow, take the name off and put another name on. Another popular way of avoiding probate, probably the most popular way, well, I should be careful about that. A popular way of avoiding probate is establishing and funding a living trust, as we talked about earlier, because if you've done that and you've effectively transferred all your assets into your trust, and your trust specifies how it's supposed to be. Upon your death, you can specify, or in the trust, you can specify that during your life, then it shall all of the assets shall be used for you, and then upon your death, the balance distributed to the following persons in the following proportions, and that will occur without having to go through probate court administration. Let me take a look at our questions here. When beneficiaries in a will don't match the beneficiaries financial companies have on their records, who carries more weight? Excellent question. The beneficiary, the will can only affect assets that are in your name at the moment of death. And if in the question's hypothetical, if on your bank accounts you have either made your bank accounts joint, or better yet, you have designated pay on death beneficiaries on your bank and credit union accounts, that will take priority because upon your death, the money in those accounts are not considered probate assets, so they cannot be affected by your will. Who's going to win? The POD beneficiary of your bank account or the TOD beneficiary of your brokerage account. But back to the living trust, an excellent tool for number one, protecting you and your family from probate court intervention if you become disabled, and similarly upon your death. And it's very, very, very useful, user-friendly, because you can make changes. The nice thing about a revocable living trust is, yep, you're right, it's revocable. You can change it anytime. People oftentimes make several amendments to their trust. It can be a one-page amendment. If it's a slight amendment, it can be a multi-page amendment. And the trust kind of remains consistent with your wishes as you change your mind going forward. Another technique that has become popular in Michigan, not available in very many states, maybe only a few other states, and that's a document called a ladybird deed. And that is useful. Let's say that you have a piece of real estate, your home, and you have no other assets. And let's say you have one adult child, and you want that one adult child to have your home when you're gone, but you don't want to use joint ownership because of all the problems that are attendant to joint ownership. You can use a tool that was used by Lady Bird Johnson, the wife of President Johnson years ago. And a ladybird deed is, instead of making your house joint with your adult daughter Mary, you can deed the house from yourself over into your name, giving yourself a life estate in the house, and then specifying that the remainder interest, that is what happens to the house after you're gone, will go to your daughter Mary, provided, however, that you haven't changed your mind in the meantime. In other words, you can, in that deed, reserve the right to change your mind with respect to who is going to acquire the remainder interest, namely the interest in the house after you die and your life estate terminates. So that's becoming more popular for those modest estates that basically only have a piece of real estate, and the client doesn't want to go to the expense of creating a revocable living trust. So let's move on to our next slide and see where we have. I'm just checking our time here, and the clock is moving along. Disability. We mentioned early on that planning for disability is one of the two areas of concern when we're thinking of an estate plan. And when we talk about planning for disability, the most common tools that we use are documents, number one, to designate a manager for our financial affairs, our property affairs, if we become ill or disabled. And secondly, a person to make medical or healthcare decisions if we become disabled. And the two documents are, one's the financial power of attorney, the second, the medical power of attorney. The first document, the requirements for a financial power of attorney, basically has to be in writing, signed by you, dated, witnessed by two people, and notarized. And before it can become effective, has to be signed by your agent, who acknowledges his or her duties of a agent under a financial power of attorney in Michigan. So who do you select as your agent? Well, you want to select, of course, an adult, someone who's familiar with your property affairs, and most importantly, someone who is a person of integrity and has good business judgment. When does the power of attorney become effective? Well, you got a couple choices. You can draft your document, your financial power of attorney document, so it becomes effective immediately, or so it does not become effective until you become disabled. Well, which one? Which one do you choose? Well, the problem of the second type, the type that doesn't become effective until you become disabled, is sometimes that creates confusion. Let's say in your financial power of attorney you specify that this document shall not become effective until I become disabled. And then you define disability to mean a letter from your primary care physician saying that Ted Hughes is no longer capable of handling his business affairs. Well, that sounds pretty good. Well, then I become disabled, and then you go to my doctor and ask the doctor for a letter stating that language that I just mentioned to you. Well, what if the doctor hesitates and says, well, I'm not really sure, or I don't want to be held liable for making that decision, or no, I don't think Ted is quite at that point yet where I can say he's disabled? Well, then you're in a conundrum. So that's one of the downsides of a so-called springing power of attorney, and that's why estate planners these days are more frequently recommending use of a financial power of attorney that becomes effective immediately. So that's something to consider. The other document is the medical power of attorney, and the requirements of a medical power of attorney are similar. Namely, it's got to be a writing, it's got to be signed by you, dated, witnessed by two people, notarized, and signed by your agent, again, acknowledging her duties under the document. Now, selecting your agent. Now, here you may want to select a friend or family member with different qualifications, namely somebody who understands your wishes in the event you're seriously injured, perhaps terminally ill, and you cannot communicate with your doctor. When does a medical power of attorney become effective? Well, first of all, it's got to be signed, as I just mentioned. Secondly, you have got to reach the point where you're unable to communicate with your physician. As long as you're able physically to communicate with your physician, then your medical power of attorney doesn't become effective. Then when you are unable to communicate with your physician and your physician signs the document agreeing that you are unable to communicate with your physician, then the document becomes effective, and your agent then has authority to make healthcare decisions on your behalf, or sometimes more importantly, to decline to authorize certain types of care. Perhaps you don't want to be kept alive on a respiratory machine. Perhaps you do not want to be kept alive by tubular feeding or other things, but simply want to be permitted to die naturally with perhaps only the administration of pain medication. Lastly, this signing a living will. I put that on the list here because people have heard about a living will. Actually, a living will is not recognized as a legal document. In Michigan, you can achieve the same result by signing a medical power of attorney. Most states do authorize a living will. Michigan does not. Living will is basically a document in which you specify what your wishes are with respect to future health and medical care. It does not designate an agent to make those decisions with you if you become unable to communicate with your doctor. Let's take a look at the next screen. Letter of instruction. This is a document I did mention briefly. A letter of instruction is basically a document that informs your survivors of what you own and where it's at and what you owe to other people, and do you have a bank safety deposit box, and do you own money to Uncle Joe, do you own a condo in Florida, do you have a bank account in Tallahassee. And the format of a letter of instruction, there is no required format. Sometimes it's simply a long handwritten letter to your family of what you own, where it's at, what are the accounts, who your financial advisor is, did you leave a will or a trust, where are your documents located, do you have a bank safety deposit box, is the paperwork stored in your office in the basement in the right-hand corner of your desk, things like that. Now, where do you get a format? Well, there is a form, letter of instruction. Actually, I've included one in my book, the Handbook on Wills, Funerals, and Probate. It's in the library. I'm not trying to sell you a book, but there is a form that I've included in that, and also that there is a form in that a pamphlet called Peace of Mind that's available at the Michigan government website. Again, going to the main website, in the search box, typing in Peace of Mind, then you'll see that very helpful pamphlet that includes not only a statutory will, but also a document called Family History. That is a letter of instruction. And lastly, let's take a look at our last screen on getting started and trying to do your own estate plan. Well, you've already gotten started by participating in this webcast, and of course, reading is always helpful. I have included a list of online resources that give you a pretty good start on getting information on doing an estate plan. There's a lot of very good websites. I've reviewed all of them, and I've found that many of them are very helpful. Should you do your own estate plan? Probably not. Yes, you can do a homemade will. It may not be enforceable because your language may not be strong enough to force the carrying out of your wishes. Let's see, I've just noticed a question, a comment by Lisa. Again, those online resources. Oh, good, very good. Thank you, Lisa. Should you do your own estate plan? Again, we see advertised so-called estate planning kits, do your own will. We see that on television. We see that on seminars. People sometimes get in trouble trying to do their own estate plan because actually doing an estate plan is a bit more than simply preparing a basic will. It's also addressing all of your other options. It's looking at your assets to determine how they are owned. It's identifying contingent beneficiaries, and really probably, particularly if you're going to consider a trust, you do not want to try to do that yourself. How do you find a skilled estate planning lawyer? Well, if you know a lawyer, if you know a general practitioner that you can call and ask for a recommendation, that's helpful. Take a look at the online sources list, particularly at the very last page of that list. There's a couple of websites that suggest organizations that you can call for recommendations for an estate planning lawyer. Sometimes if you're in a community where there's a law school, for example, our local Cooley Law School has what's called a 60-plus legal aid program, and it doesn't matter what your assets are. They will help you with an estate plan free of charge if you're simply 60 plus or older. Attorney fees, a very important subject that you should raise if your lawyer doesn't raise early on. If you call an estate planning lawyer and are asking for a little information, ask them to mail to you their fee schedule. Another way to check on an estate planning lawyer is to go to their website. Typically have biographical sketches on the lawyers in the firm. And then lastly, we're safekeeping documents. I just touched on that, but your options are probably your best option is a bank safety deposit box. Yes, I realize that if you have a simple will and you want a place to store that, you can go to the probate court and they will store a will for safekeeping for $25 in Michigan, but that's only for a will. Many times an estate plan includes other documents besides the will, specifically the trust and the funding documents. So consider a bank safety deposit box, and they're about $20 a year in Michigan. Sometimes people use a home safe that's fireproof. And but the important thing is you want to choose a place for safekeeping documents that, number one, is safe, really, from fire and theft. Number two, from loss. And number three, just as important as the others, are a location that's likely to be found by survivors. That's very important. I see my time is running out, and I'm just checking the questions. I don't see any more questions, so I will just thank you for taking the time to learn about this very important topic, estate planning. Thanks. Bye-bye.
Okay, and this is Lisa. Thank you for joining us today, and thank you, Ted, for all of that wonderful information because I am impersonating Brenda at the moment and sitting at her workstation. I've already seen some of the emails coming in showing appreciation for the depth of content. As we've mentioned multiple times, you will be receiving an email from the Alumni Association to the email address that you used upon registration that will give you the recording of this cast and will also provide to you those resources that Ted referenced a number of times. If you are interested again and you are in the mid-Michigan area, I'm going to advance our slide here. Ted will be conducting a 4-hour course through the alumni lens on Saturday, February 22nd at the Kellogg Center. If you are interested in learning more about that and registering, you may do so at alumni.msu.edu/the lens. And if you have additional questions for Ted, you are welcome to reach out to him. I'm going to jump back to our previous slide for Ted's contact information, and I will leave this slide up for a moment. We are at the conclusion of our webcast, but I will leave the web room open for a moment so you can record Ted's contact information. Thank you again, Ted, for your time and this valuable information. And for those of you who are curious what's coming up next in our professional series webcast on Thursday, February the 13th from 12:30 to 1:30 p.m. Eastern Time, we will be talking about licensing and copyright basics. So that's a bit of a switch. And then joining us 2 weeks from that time, on the 27th of February, the MEDC, Michigan Economic Development Corp, will be talking with us about how employers can recruit talent in Michigan. So thank you for your support of the MSU Alumni Association and your participation in our professional series. If you have ideas of what you would like to see us cover in webcasts in the future, you are welcome to contact. I will use Brenda's web address since it's already in the chat area. Brenda Haynes at haynesb@msu.edu. Thank you and have a great